Indian News 24-hour.
The court acquitted former telecom minister and DMK leader A. Raja, his party colleague and MP Kanimozhi and 16 others in the 2G scam, which rocked the telecom industry in 2011. The special court that pronounced the 2G verdict hauled up the telecom department for what it termed inefficiencies, convoluted way of writing down guidelines, disordered functioning and a lack of understanding of regulations. Non-understanding of issues in proper perspective led to a suspicion of grave wrongdoing, where there was none, at least as per record of the court, Judge Opsini said in his judgment on Thursday, adding that this factor had greatly contributed to the controversy. The court acquitted former telecom minister and DMK leader A. Raja, his party colleague and MP Kanimozhi and 16 others in the 2G scam, which rocked the telecom industry in 2011 and was widely seen as key to the then-ruling United Progressive Alliance's defeat in elections 3 years later. The court pulled up the Department of Telecom. Over its submission that it was cheated by promoters of the SR Group and Loop Telecom by fraudulently obtaining 2G spectrum licenses, saying the was playing victim. The order said despite DOT's claims that some guidelines were not followed, it did nothing as part of a course correction. It referred to the deposition of a DOT official as a prosecution witness and said the department had received a complaint earlier, but did not take it seriously on the ground that it could be frivolous. Accordingly, DOT went ahead with the signing of the license agreements. Thus, DOT itself did not take the complaint very seriously. The deposition of A.K. Srivastava, a DOT official alone is good enough to knock out the case of the prosecution, it said. The court said DOT knew about the allegations in the complaint in advance, but started wallowing into victimhood at the instance of CBI. Further criticizing the department, the judge said a lack of clarity in the policies as well as guidelines added to the confusion. The guidelines have been framed in such technical language that meaning of many terms are not clear even to DOT officers. When the officers of the department themselves do not understand the departmental guidelines and their glossary, how can they blame companies others for violation of the same? The order read. A large part of the controversy revolved around the usage of words like associate, promoter, stake, and the judge said the DOT officials did not know their meanings despite using them in the regulatory policies. The interpretation of these words is haunting the DOT since these words were first used, but no steps were taken to assign them a specific meaning. In such circumstances, DOT officers themselves are responsible for the entire mess, the judge said. The court highlighted what it termed as the telecom department's inefficiency in recording and storing data. The technical and verbose language used is up for interpretation and can conveniently be used for finding fault with the superior authorities for agreeing to or disagreeing from it, as the case may be, the court said. The haphazard way policy files were maintained and an illegible way of recording that added to the confusion in the case that dragged on for more than 7 years. Notes have also been recorded on extreme margins of the note sheet, some of which have become frayed with the passage of time and cannot be read and understood properly. Non-understanding of the official notes by outside agency creates an impression of wrongdoing, said the judge. The court noted that the policy decisions of DOT were scattered in different official files and were difficult to trace and understand. The 2G scam tainted the Congress-led UPA government, which found it impossible to shake off the label of corruption as other scandals also erupted. This stirred up an anti-corruption movement that gave rise to the Aam Aadmi Party. The BJP then turned it into a powerful campaign plank that in part helped it defeat the UPA in the 2014 elections. The 2G spectrum saga on failure of CBI and prosecution for the last about 7 years, on all working days, summer vacation included. I religiously sat in the open court from 10 a.m. to 5 p.m., awaiting for someone with some legally admissible evidence in his possession, but all in vain. Not a single soul turned up. Everybody was going by public perception created by rumor, gossip and speculation. However, public perception has no place in judicial proceeding. In the beginning, the prosecution started with the case with great enthusiasm and ardor. However, as the case progressed, it became highly cautious and guarded in its attitude, making it difficult to find out as to what prosecution wanted to prove. However, by the end, the quality of prosecution totally deteriorated and it became directionless and diffident. On Raja and Kanimozhi, there is no oral or documentary evidence to link the transfer of 200 crore rupees to Kalaignar TVP Limited with Shish Araha. It is the case of the prosecution that the familiarity between A. Raja and Kanimozhi indicates conspiracy. However, this argument is also not supported by any evidence. If two members of parliament, belonging to same party, meet each other, by itself, there is nothing wrong in that. INACTION of ABA officials. The action or inaction of officials belonging to various departments, that is, Law Ministry, Finance Ministry and PMO, shows that the controversy about the issue of LOAS on January 10, 2008 and subsequent grant of licenses and allocation of spectrum arose due to unnecessary questions and objections raised by some of the officials and unwarranted suggestions put forward by others. None of these suggestions were carried to logical conclusion and were left unaddressed in between. On Department of Telecommunications, the guidelines have been framed in such technical language that meaning of many terms are not clear even to officers. When the officers of the department themselves do not understand the departmental guidelines and their glossary, how can they blame companies others for violation of the same? The order read: unexplained delay, unwarranted and unexplained delay in examination of witnesses. No plausible explanation has been given for the delay except citing the high-profile nature of the case. This puts a cloud about fairness of investigation. There was no expeditious investigation in this case. On registration of the case, for more than a year, almost nothing was done in the case, and then suddenly all the witnesses were recorded one after the another as if the investigators had all of a sudden gained all the knowledge of the case and the witnesses had also become source of all the information. Allocates 1076 for UP Chief Minister Helpliner Com drops after OK's merger with SSTL. Seeks industry view on licensing structure overhaul. Recom Sistema Xiam merger gets approval. Approaches try on review of spectrum caps for telecom companies.